But anyways, we can all see. And Ms. Myers, what's your relation to Miss Shirley Davis?
Daughter-in-law, fiance to her son Sheldon.
So
Me.
you're engaged to Sheldon, okay.
She's been with me like 15 years, 13 to 15 years.
Okay. I'm just gonna know who's who. Okay. All right. I guess this is everybody that's going to be joining us. So, what this hearing was set for, probably everybody knows, is
My oldest brother Lawton is also somewhere in there.
well, he's not in the Zoom waiting room yet, but as soon as he comes in, we'll bring him into the meeting.
Okay.
So, as you know, the decedent died in January of this year. Was not married, didn't have a will, which means it goes to the estate goes to the children. There's the three of y'all. There's Armand, Sheldon, and Lawton. And Armand has filed a petition for administration seeking to be the personal representative of the estate to get the estate probated, which means to collect any assets of the estate, pay any debts that need to be paid, and then distribute whatever's left over to the three of you all. And so that's where we are. And I understand that Mr. Sheldon Davis objects to Armand being the personal representative, correct?
Very. Yes, sir. Correct.
Okay. And I did receive just a little while ago, you had dropped off to the clerk a letter with some photographs, and I don't know that Mr. Keever has this. Anytime you supply something to the court, you really should supply it to everybody else. I'll read it just so Mr. Keever is aware of what was delivered to me just a little while ago. It's addressed to me from Mr. Sheldon Davis. And it says on the flash drive, apparently there's a flash drive in this envelope. I have not attempted to look at that. It says on the flash drive, the first video is security camera footage from Shirley and Lawton Davis's home of Armand Kareem Davis Sr. taking his Nissan pickup truck that I nor my parents who live there have any record, word of mouth of him buying or bill of sale or being gifted. Thus, reasons for the Nissan titles I've also submitted to the court. The second video is a video of the afterwards effect of a mysterious house fire on the house of Shirley Davis, left Sheldon Davis by right of survivorship less than 60 days after Shirley Davis' funeral. I alone paid for it. Granted, I have no video proof of him creating this incident or how this took place. I can only assume. Armand Davis has made numerous threats to my mom, who's now deceased, myself, and my brother. Armand Davis Jr., I guess it should be an I recently changed the locks of my mom's house. She also left me by right of survivorship because he was coming in my house taking things out of there when I was not there. These are just some of my reasons why I asked the court to dismiss any thoughts of Armand Davis petitioning anything else to have to do with the estate of Shirley Davis or anything else. I and my older brother Lawton Jr. would like to be left alone. My mom left things the way she wanted them. Thank you for the court's time, and it's signed by Mr. Davis. So that's that. And there are some photographs. I guess there's an invoice from, looks like the monument company for a headstone. A photograph of a door. The door jammed. Looks like it's damaged. And then some evidence of a house fire. A gasoline can in the front yard, and death certificates of Shirley Davis and Lawton Davis. A cash receipt. I guess that's for the cemetery. Yes, and the Bivens funeral home. Okay, so that's what was provided for me
Right.
today, so everybody knows. So
all paid by me.
So go ahead, sir.
I said all paid by me.
Okay. And you're entitled to be paid back for that. So assuming there's anything to pay back with. So it's Mr. Keever's petition. Mr. Keever, if you want to go ahead and tell me why your client should be appointed as the personal representative, then Mr. Sheldon will probably tell me why he shouldn't be. But let's start with you.
Sure. Thank you, Your Honor. Again, Chris Keever, I represent Armand Davis, who's filed the only pending petition for administration seeking appointment as personal representative of the estate. This is an intestate estate, so there's no last will and testament of which we're aware or which has been found. The decedent, Shirley Davis, is Armand's mother. She is survived by 3 children, so Armand and Mr. Sheldon Davis, and then Lawton Davis Jr. is the 3rd child. So under Florida statutes 733, 303, the preference would be between the 3 as personal representative. However, as stated in the petition, Mr. Sheldon Davis had been convicted of a felony, so he would not be qualified to serve as personal representative, nor do I think anything he's filed asked to be appointed. And previously, as the court record shows, Mr. Lawton Davis was served with formal notice of the petition for administration. He's not filed anything to date to object or otherwise. So at this point, I really think we only have, one candidate to be personal representative as it stands. Even if that weren't the case, though, I think it's helpful for the court to note that what we believe is coming down the pike here. There's one property left in the decedent's name, 5656 Gilchrist, a piece of residential real estate. However, there were, I think, 11 other parcels of residential real estate that originated with the decedent's husband, who predeceased her. He passed back in August of 21. Probate proceedings were held here in Duval County, and that was also an intestate estate, so the decedent ended up receiving the full estate because all 3 children were mutual to the marriage of, I believe, 52 years. After conducting the probate proceedings, 10 of the 11 properties were quitclaim deeds were executed for 10 of the 11 properties. Again, 5656 Gilchrist being somehow excluded, but those deeds put Mr. Sheldon Davis or 9 of them put Mr. Sheldon Davis as co-owner of the properties with rights of survivorship. The 10th went to Mr. Lawton Davis. So those 2 of the 3 children, and Mr. Sheldon being the majority beneficiary there, received the bulk of the assets that we believe belong in the estate. We believe that because, as you can see from the deeds, the decedent's name is written incorrectly, has the wrong middle initial. So there's only one of 3 explanations we can gather from that: is that either she didn't remember her middle initial, or she was told to write the wrong middle initial for some reason and she went along with it, or somebody else did it and they just didn't know. That's the only 3 logical conclusions we could come up with. Mr. Sheldon Davis, as he himself has said in some of these court filings, once his dad passed, he was the one who started taking care of his mom. He lived behind her, and then proceeded to spend the majority of his time at her house. So really, we feel like undue influence is at play here, and so we believe the presumption is going to be established, and that's what we think the bulk of this estate is going to be. We've got the one property that is in the decedent's name, but we do believe that legal proceedings are going to be needed down the road to look into these deeds that were done that really transferred the bulk of what the decedent owned, which, again, we find problematic because of the wrong name on the deeds, which my client has since reported the notary to the state of Florida, and their conclusion is that he he was wrong in some way. We don't know the specific way in which he was wrong, but the letter that my client received clearly said after their investigation, they found that the notary, Bernie Bivens, did something wrong and that he was going to face remedial action for that. The fact that Mr. Sheldon Davis was the almost exclusively the primary beneficiary of these deeds, and the fact that Ms. Davis, the decedent, had on more than one occasion stated her intent that all of her children share equally in her estate. In fact, it was said as recently as I would know it to be in guardianship proceedings that were brought here in Duval County after the deeds were done and came to light. And one of the examining committee members notes in her report that Mrs. Davis stated that everything she has will go to her 3 children. So this was an examining committee report done after the date of the deeds, stating the decedent's intent that all 3 of her children receive her property equally. At least that's what she thought was happening. So there are a myriad of red flags here that we feel like need to be investigated. So even if Mr. Sheldon Davis didn't have a felony and were disqualified from serving as personal representative, we think that there's a clear conflict of interest that nearly equally applies to Mr. Lawton Davis, as he was beneficiary of a property as well, which it seems like a token for him to go along with. And I think what my client would tell you, what many others will testify in future litigation and proceedings, is that the dynamic between the decedent and her husband is that her husband was that traditional head of household. He made all of the major decisions, handled the finances, and I think that's reflected in the fact that those properties were owned solely by him until his date of death. It was the only exclusion was the homestead that was owned jointly. When he passed, Mr. Sheldon Davis filled a void. So she was already accustomed to 52 years of marriage where the head of household made all the major decisions. Again, and it reflected in this examining committee report as well. And so she was vulnerable. She was taken advantage of. And so that's where we think this is headed, and why we think that's relevant to today's proceedings is that Armand's the only one that was out of the picture, even though Mrs. Davis clearly said she wanted all 3 of her children to benefit equally. Now, all of a sudden, the vast majority of property she inherited from her husband now belongs, or at least in title, is in Mr. Sheldon Davis's name.
Thank you very much. Mr. Sheldon Davis, did you want to say anything, sir?
I most certainly did, yes. If you notice that my mother forbid Armand Davis from even coming to the house, my house, or Gilchrist after the less than a month after my father passed, because he stole the truck. And he started doing a lot of stuff behind the scenes. I don't know whether you've been given that notarized letter that my mother signed herself less than 30 days. Right. So this Armand made this bed hard for himself. You can't, you can't mistreat your mother that way. For the numerous times that he sent the police here, for the numerous accusations that he said that his mother was being abused, that he sent the police here for wellness checks and things of that nature, my mother became very upset with Mr. Armand Kareem Davis. And these are some of the reasons why she felt he was not trustworthy at all. She's already been through a capacity court as well that she had to go through with numerous social officials and have a lawyer present and all, by this same lawyer who omitted to not saying that he was the same lawyer that actually tried to say my mother was incapacitated and she passed with flying colors and so forth. So if you can see the pattern of ball dropping all the way up until the last court proceedings, to where I nor my older brother or Tiffany could not even get into this Zoom meeting at all, because we wasn't even given the passcode. So that's what.
Well, that's what we're doing today. As soon as you came in and told me that, I said, okay, we're going to unwind everything. So
Right.
I'm sorry you didn't get that information, but I didn't make any rulings or anything like that. So.
Right. I understand, but I'm just showing you a pattern of dropping the ball and things of that nature. And like I said, Armand did this to himself to where she felt more comfortable with me being the executor or choices and things of that nature. Not just because she was with my father since she was in the 8th grade. It was because of trust factor that included there. I mean, you can't try to put your mama in a home and think things are going to be great. You can't do these types of things the way you stop going to church. My mom, these are personal things that I don't even like bringing to the light because my family has always been a prideful type of people. But after these particular things, and like I said, the home I'm in now at 5040 Doncaster, he's already been in here stealing or taking things out of here. That's what made me change the locks, like death certificates and paperwork and stuff for stuff as far as life insurance, things of that nature. And he's just not a reputable person, period. And the only reason why my mother didn't press charges before, while she was still alive, is because she didn't want him to lose his post office job. So I don't even think there's a reason, period, for this. And that's where I am with that. I mean, I could give you numerous of situations, proof, and all that, but I'm sure the judge can already see where we're going with this. For someone to try to,
I think I get the gist of it. Let me ask Mr. Lawton. Sir, can you hear us? Okay.
Yes, sir.
Do you want to add anything? I think you missed the first part, but Mr. Keever was telling us why he believes, or Armand believes, that he should be the personal representative, and you just heard Sheldon.
Yes.
Do you have an opinion? You want to weigh in on this?
No, sir. My brother said everything correct, word by word.
Okay, so you would favor Sheldon over Armand. Is that what you're telling me?
I favor Sheldon because we took care of Mama the best way we could. We spent the night with her, took her to church, and we didn't want my mama to have no burden on her in her last days, and we did all we could for Mama, and I spent the night with her. We ate with her, and also we spent the night with her. I took her to church. When my middle brother Sheldon had to go out of town, do certain things, and he came back, I was there. Then I went to work, and I ain't want anything. I just want my mama to live a good life and do everything that our father want us to do if he was still living. Because my parents mean more to me than what my favorite brother trying to do.
Yeah. So here's an issue. Mr. Sheldon, you've got a felony conviction. Is that right?
About 30 years ago, when I was in the Marines, I got, but that has been expunged and all that since then. I mean, we talking about this was what, 95, 96, 97.
Well, it wasn't. If it was expunged, it wasn't a conviction then.
Okay.
But do you remember what you were arrested for?
It was a conspiracy for marijuana.
The only reason I ask is, under Florida law, if you've been convicted of a felony, you're not qualified to serve as a personal representative in a probate case.
Yeah, but that's been set aside.
It would be a disqualification, but anyways, so that's one thing. Do you vote? I mean, are you a registered voter?
Yes, sir. I just voted in this election.
So you're not likely a convicted felon then.
No.
Okay. So the other issue is nobody else has stepped up and asked to be the personal representative. Only Armand has.
Well,
I gotta appoint somebody.
Well, see, the most of the issues was when when my mother decided to hire Bernie Bivens, to go over the properties and so forth, she had virtually made up her mind about who she trusted, and that was it. So I mean, when we talk about estate, I mean, if the properties virtually had the right of survivorship on each property for that, and the only reason why we went into the where we could avoid going into probate in the first place, that was the whole purpose of us going to see Bernie Bivens, to have these things drawn up in the first place. So,
Well,
you know,
it's yeah. Mr. Keever said the only property in the estate right now is the one parcel. He said, although there may be a challenge coming down the pike, we're not dealing with that today, to the transfer of the others. I mean, if that happens, we'll discuss that at some point in the future. Okay. Right now, the only property in the estate is this one property that I don't have the street address, but it's the one that Mr. Keever had mentioned. I guess it's Mr. Keever. What's the street address of the one property that's in the estate right now?
5656 Gilchrist.
Okay.
I don't think Mr. Bivens missed that one. I'm not sure of that, because
Well, that's one thing that you will sort through, during the probate administration. Well, I think I have to appoint Armand as the PR, as the personal representative, because nobody else is asked to do it.
well, we didn't know that it was needed. We thought we had already covered that with Bernie Bivens.
Right, but you've known about this for a while.
Yeah, I mean,
it may be that it may be that you don't really care, but I don't know.
Excuse me? No, I mean that if anybody that comes off the road, I've been a trucker and a entertainer for the last 30 years. So when it came to my mother, my father, and my grandmother, who I buried each one of them, I took out the time to go do so. So no, if anybody did anything, it was me. So
No, I get it. Nobody's arguing that. Okay, but I mean, I just don't see where I've got any choice at this point. Armand is the only one that said he wants to do it.
Well, when you got somebody that's already been doing it, it's kind of hard to say I'm already doing it.
Okay.
So that's my point.
Well, this is what's going to happen. I'm going to appoint Armand as the personal representative. If you want to come in, if you want to hire an attorney and challenge that and get yourself appointed, you remove him and appoint you. You're free to do that, but you have to have an attorney to do that. You can't do it yourself. And under Florida law, a personal representative has to be represented by an attorney.
You know what? I don't exactly follow that.
Okay, I'll say again. Under Florida law, a personal representative of an estate must be represented by an attorney.
So in other words, him stealing the truck and the video and all this other stuff doesn't matter. Is that what you're telling me?
I didn't say that. You did not hear me say that.
Yeah, but
all that will be accounted for in the probate action. But and let me tell you, being a personal representative is not a prize. It's a pain. It's a fair amount of work. But he will be working with his attorney. But anyways,
see, that's my issue with it. If I've been doing it all along, I didn't feel like I didn't know whether I needed to have myself appointed for something that I'm already doing.
Okay.
I mean,
okay. Fine. I don't know. I don't have a response to that. I mean, you've known about the estate. You've obviously been in touch with Mr. Bivens. You know a lawyer. You probably know more than one. You haven't to this point in time. You haven't asked to be named as the personal representative.
Well, I want to be the personal representative.
You need to hire a lawyer and come in and have him or her represent you. Because under
You know, is there any way I want to get a because you said if he has a felony, he can't do this, correct?
Right.
All right, so him shooting his baby mama's brother is not a felony?
I don't know. Was he convicted?
Yeah, he did. He was in jail for over a year.
I don't know.
But
nobody has raised that. If he is a convicted felon, then he is disqualified. But I don't have that in front of me. Nobody has raised that. Nobody's provided me with a certified copy of a judgment sentence or anything like that. So, okay. All right. So this is what we're going to do. Mr. Keever, send me an order in letters. Put in the order that any cash equivalence has to go into a restricted depository account. Okay. If anybody else wants to challenge this and to get and to boot Armand out as the PR, as a personal representative, get a lawyer and talk to him about it. And if you decide you want to move forward on that, you can come in and file a petition to remove him and get yourself appointed. But nobody's done that to date, and I got to get this thing going. This case is almost a year old. So, okay.
And you know,
yes, sir, go ahead.
So him being arrested, doing time for shooting, I'm like, and I'm the only responsible one that's been doing all the work. Period. Meaning like everything that had to be done with my family, with my grandmother, father, and mother, and you know what I'm saying. I mean,
It's kind of like this. You may think you would make a better governor than Ron DeSantis, but you didn't run, so you don't get to be governor.
Well,
you may think you'll make a better personal representative than your brother, but you haven't applied. And I got to appoint somebody. So I'll leave it at that.
Can you put this aside?
If you feel like you want to pursue this anymore, speak to an attorney.
Right. Is there any way that you can since this is really the first time I've ever actually seen any judge about this case, because like keep in mind, I didn't even receive. I've been living in the same spot. I haven't been running around, none of this stuff. So the length of time that it took was the negligence of the lawyer and whoever else had to try to give me these papers in the first place. So, and it's not like I've been running from anybody. I've been in the same house the entire time. So I guess what I'm saying is,
okay.
That's my grounds for putting it off to another date.
Well,
because like I wasn't even contacted during these so many months at all. And I mean, it's not like he doesn't live 2 blocks from me. It's not that the lawyer doesn't know who I am or who he wanted to meet or anything like that, because we've been in court together already when my mother was fighting for her capacity. It's the same lawyer.
Okay. I got to go. I've got a bunch of people stacked up in the waiting room. I've got another hearing right now. I'm sure we'll talk about this some more, but in the meantime, I'm going to appoint the personal representative, and we're going to get this thing out of the starting block. Okay. Y'all have a good day. Thanks for being here. Bye-bye.
And that's bullshit.